Hi everyone, welcome to Lobus. Today we'll be dealing with a Maxim Audi Alteram Partem, that is here the other side. This is one of the important principles in natural justice. There are three different principles of natural justice which we'll see in another video. Today we'll see Audi Alteram Partem. Okay, so now we'll move on to the video. Let's check out. So Audi Alteram Partem. What is that? Audi Alteram Partem simply means here the other side, or no man shall be condemned unheard. Okay, this is the basic concept of principle of natural justice. Okay, what this doctrine says, the doctrine states that no one shall be condemned unheard, and this ensures a fair hearing and fair justice to both the parties. Under this doctrine, both the parties have the right to speak. No decision can be declared without hearing both the parties. The aim of this principle is to give an opportunity to both the parties to defend themselves. So these are the basic things what you can see and what you have to follow in Audi Alteram Partem. What are they? No one shall be condemned unheard. There should be, this is a basic thing. What the other person has to say, the court has to check it out. Okay, this is a basic thing in Audi Alteram Partem. So it ensures fair hearing and fair justice for both the parties. If a decision is taken without hearing the other party, it cannot be set as a fair justice. Fair justice has been done to that party, right? So both the parties have the right to speak here, and the aim of the principle is to give both the parties to defend their point of view or what they have to say. Now, case law we can see here this Menaga Gandhi versus Union of India. It has been held that the law and the procedure must be fair, just and reasonable. The principle of natural justice come into force when no prejudice is caused to anyone in any administrative action. Okay, so there should not be any kind of prejudice occurring here. Now, in another case, you can see that S.A. Khan versus State of Haryana. A deputy inspector general was suspended based on complaints, and he argued that he was not given a chance to be heard. The Supreme Court held where the decision making process involves multiple decisions, multiple disciplines, a formal hearing may not be necessary. Okay, in some cases, Audi Alteram Partem will not be followed. There are some exemptions also. Okay, now exemptions that I will see later. So here in this case, the court held like that. An example you can see is that a failure to inform a person of a case being made against them and an opportunity of being heard may result in the matter being dismissed or decision of the government body rendered void. So both the parties has to be heard before taking a decision. So there are two elements to Audi Alteram Partem. That is, one is notice and one is hearing. So the first one, notice. Now the important thing, what is that? Before any action is taken, the affected party must be given a notice to show cause against the proposed action and seek his explanation. So the other party has to be sent a notice by the party who is having any issue, right? And these are the things what he is going to do. The notice, in that notice it has to be stated. So any order passed without giving notice is against the principle of natural justice and it is void ab initio. We have seen in our maxims what is void ab initio, that is void from the beginning. That is from the beginning itself it is void. So before taking any action, the right of a person to know the facts Without knowing the facts of the case, no one can defend himself, right? So he has to be informed. What are the in a notice when you're sending a notice? What all things must be there in a notice? There has to be time, place, date of hearing, jurisdictions under which case is filed, the charges and proposed action against the person. These all things must be there in a notice. Okay. So in a case, Punjab National Bank versus All India Bank Employees Federation. Yeah, the notice contains certain charges, but the penalty was imposed on the charge other than those mentioned in the notice. Okay, so there was a notice sent, but when the penalty was imposed, it was not for the things what was for the complaints which was mentioned in the notice, but for other things. Thus, the charges on which the penalty was imposed were not contained in the notice served on the person concerned. So, what happened? The notice was not proper, and therefore the imposition of penalty was invalid. So when you are sending a notice or a petitioner or a injured party is sending a notice to another person, okay, whoever is sending a notice to another person, it has to state some things which I have mentioned earlier, that all things must be there in a notice, without which if you're seeking some relief and the decision comes and another thing, it cannot be set as valid, because you have sought a thing for something and you are getting for something, it is not cannot be set as a valid thing. So in Cashier Mill Company versus Union of India, the notice is required to be clear and unambiguous. Okay, it is if it is ambiguous or vague, what happens? It will not be treated as reasonable and proper notice. So without any prejudice, it has to be unambiguous. Okay. If the notice does not specify the action proposed to be taken, it is taken as vague. It is not a proper notice. It is not considered as a proper notice. Okay. So the next element of Audi Alteram Partem is hearing. You have to hear, right? The second ingredient is Audi Alteram Partem is this. The person concerned must be given an opportunity of being heard before any adverse action is taken against him, right? Okay. And historic case or landmark case we can say is that Cooper versus Wadsworth Board of Works. Okay, the defendant board had power to demolish any building without giving any opportunity of hearing if it is erected by permission. So, and an authority is that you have to seek a permission from that authority. If you are not seeking a permission from the authority and you're doing something, that authority has the authority to do the necessary things according to the law. Here what happened, the person has erected a building without seeking permission from the concerned authority, and what the board demolished the house of the plaintiff under this provision. The action of the board was not violative of the statutory provision. Okay, in the statutory provision it was that if there is no permission, the board can take any decision. Okay, so what court held? The board power was subject to the qualification that no man can be deprived of his property without having an opportunity of hearing. So they have to have an opportunity of hearing. This was the thing of the court. Even if something is mentioned, there should be a proper notice of the person what what the other person has to say. This has to be checked. That was the court's decision. Now, in another case, National Center Cooperative Bank versus Ajay Kumar. If the order is passed by an authority without providing the reasonable opportunity of being heard to the person affected by it, adversely will be invalid and must be set aside. As we said, the person has to have an opportunity of hearing or the opportunity of to defend himself, what he have to say, that has to be given. Okay. And in A.K. Gopalan was a state of Madras. What was that? The fair hearing was taken up. Or you can say the reasonable opportunity of hearing, which is also a well known as fair hearing. Fair hearing, fair justice. So fair hearing was seen here. So is an important ingredient of the Audi Alteram Partem rule. Fair hearing must be there. It was checked in A.K. Gopalan versus State of Madras. Now, evidence in principles of opportunity of hearing, and there are some of the points. The first one is evidence. Okay, in evidence, what is that? The adjudicating authority must give full opportunity to the affected person to produce all relevant evidence in support of the case. So when an adjudicating authority is there, so the person has to be given an opportunity to produce all his evidences to support his contentions. Okay, the adjudicating authority must disclose all evidence or material placed in the course of proceeding, and what all the evidence has been given, that all has to be produced before the court of law and to defend his case. Any material or evidence adduced by one party cannot be utilized against other party unless an opportunity is given for explanation, criticizing or rebutting of the evidence is permitted. Okay, so these are the things in evidence. So in case in R versus Boardman, evidence is an important part which is to be brought properly before the court in the presence of both the parties, and the judicial quasi-judicial authority must have to act on the evidence produced. What all evidence has been produced by any person, that has to be checked into. What are the things the person has to say, or what are the points which the person has to say? This all things authority has to check into when an evidence is produced for the hearing. Okay. And that's why Cotton Mills versus CIT, the petitioner was denied the opportunity to produce some books of accounts before the income tax tribunal. The court held that the refusal to give an opportunity to produce evidence in his favor amounted to violation of natural justice. When you are put into a situation and you are being pointed that this was the thing, is what you're doing is not fair, and so the person affected by the contention has to give an opportunity to defend himself. And here the income tax officer, the petitioner, was denied that, and it cannot be set as a valid thing. So it was set as a violative of natural justice. Okay. Now the second principle of hearing is cross-examination. Right to cross-examination of the witness need not always be given to the concerned person. Okay, the concerned person only has to defend to cross-examine. It is not like that. Okay, it depends upon the facts and circumstances of each case and the statutory provisions. Hira Nath Mishra versus Principal Rajendra Medical College. The appellants were the students of medical college. This is one important cases in cross-examination. Okay, the appellants were the important students of medical college. They were accused of serious misbehavior with girls inside the premises of girls' hostel. The complaint was made against them after the injury. They were found guilty and rusticated from the college for 2 years. They claimed that the principle of natural justice were not complied because the names of the complainants were not told to them. Neither any opportunity of cross-examination of witness were provided to them. So the said order was challenged by the appellants as violative of natural justice because the other person, the boys, were not given an opportunity of to defend themselves. What was that? They argued the statements of the girl students were recorded privately and no opportunity was given to them for cross-examine the girl students. Hence, the principle of natural justice was violated. This was a contention that their natural justice, the boys' natural justice, was not followed and it was violated. So, what the court held, the Supreme Court, after hearing the contentions, what it held was that rejected the contentions of the appellants and upheld the order of restriction because the girl students what they have found out was right, and some of the cases this principle of hearing cannot be given. This was the contention of the court and it upheld the contention of the appellants. The next principle of hearing is legal representation, where the right to be heard include right to legal representation. In Modi versus State of Bombay, the representation through a lawyer in the administrative adjudication is not considered as an indispensable part of fair hearing. But in certain situations, if the right of legal representation is denied, then it is amounting to a violation of natural justice. So, legal representation has to be a natural justice. Is the natural justice. Everyone has the right to be represented by a lawyer. Okay, in Krishna Chandra versus Union of India, the denial of legal representation will amount a violation of natural justice because in such condition the party may not be able to understand the question of law effectively and therefore it should be given an opportunity of fair hearing. What is that? There should be an opportunity of fair hearing given to a person, and the person has to have a provision of having an advocate represented or a legal person representing him. This was the other thing in hearing. The other thing is empty formality theory. What is that? Have you heard about empty formality theory? It simply is that if a principle of natural justice are not observed and penal action is taken, the action is liable to be set aside. Okay, if hearing is not permitted by an adjudicating authority to the person concerned, the principle of natural justice are violated, and such action can be sustained on the argument that even if notice is issued or hearing afforded, there is no differences or no use or purpose would be served. So, in other words, it is an empty formality. So, what is that? If the principle of natural justice are not observed and penal action is taken, the action is liable to be set aside. So, there has to have in every provision there has to have a principle of natural justice being done to the affected party, the party which the party has to say, the court has to check into it, other evidences has to be taken and everything has to be observed, formalities, notice has to be served, hearing has to be done. These all things are there in the Audi Alteram Partem in order to serve a fair, reasonable and just judgment to the other party, and there should not be any kind of biased or any sort of prejudice being done. So, in a case Board of High School and Intermediate Education Yukes versus Chitra Srivastava. Here, the board cancelled the examination of the petitioner on the ground that there was shortage of attendance at lectures and no notice was given to her before taking action. So, this petitioner had a shortage of attendance in her studies, so the examination was cancelled. So, the petitioner challenged. The petitioner was not allowed to attend the exam, so this was challenged by the petitioner. The board contention was that the facts were not in dispute and no useful purpose would have been served by giving such notice. Even if she didn't have the attendance, she knows it. Even if the notice was served, it is not going to serve any purpose. This was a contention of the board. And what Supreme Court held was that Supreme Court did not uphold the contention and held the board must follow the natural justice principle. Okay, and hence it is violative So order of cancellation of examination was set aside. So even if the other person is knowing about something and is aware about what is being done, what is his problem or something, in this case she knows that she has to appear for the examination, but she didn't have a proper attendance, so she cannot attend the boards. And the board also contented that she had enough knowledge, that she didn't have the attendance, she didn't have the proper things, which was one of the criteria for the examination. So there is no purpose in serving the notice or anything, because the other person knows the things. But there has to, in the natural justice principle, when you follow that, the person has to be given a proper notice and it has to be informed. This was the contention of the court. And the examination, the order of cancellation examination was set aside by the Supreme Court. So the natural justice principle was not followed. So natural justice has to be followed in every case. This was the thing which the court observed. So when you're following the natural justice thing in a case, there has to have a proper hearing, proper notice, everything has to be served. Here it was not served, so the court has taken the decision and hence it was set aside. So this was Audi Alteram Partem, and we'll see the other principles of natural justice in another video, and what is natural justice and what are the principles in detail in another video. Now that's all for today, and we'll see in the next video. Before that, please do share, like and subscribe if you like my video, because if you subscribe, you'll get the notification when I put a new video. And that's all for today. We'll see in the next video. Thank you.